Good evening, everyone. The October 15th, 2025 Arlington County Board of Zoning Appeals is now in session. I am Richard Kaplan, Chair of the Board of Zoning Appeals. The board is made up of 5 citizens appointed by the Circuit Court. Tonight, in addition to myself, we have members Inta Mellis, Judy Freshman, Carol McCoskry, and Alex Kumana, who is joining us virtually tonight. Also present is the professional staff, including Megan Ryan, BZA Associate Planner, Brett Goldberg, BZA Associate Planner, and Stephen Rissy, Zoning Prim Supervisor, who is also joining us remotely tonight. To avoid disruptions, we ask that you please place your mobile devices in silent mode. Before we begin tonight's hearing, I will discuss this board's powers and procedures for tonight's hearing. The board's powers are prescribed in the Code of Virginia and are set out in further detail in the county's zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend regulations set forth in the ordinance. That authority rests with the county board. This board does have the authority to do 3 things. First, the BZA can approve use permits that allow modifications of placement requirements for structures on 1- and 2-family lots where there is no option in the zoning ordinance to allow such modifications. In order to approve a use permit, the Arlington zoning ordinance requires that this board find that the proposal will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not conflict with the purposes of the master plans and land use and zoning related policies of the county. In making these findings, the BZA shall consider whether that modification will promote compatibility of the development with the surrounding neighborhood because of the structure's overall size, footprint, and placement are similar to those of structures on the property surrounding the lot in question, and whether the modification will help preserve natural landform, historical features, and/or significant trees and foliage. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary and in the public interest, including but not limited to the duration of that use permit. Second, the BZA can grant variances from the specific requirements of the zoning ordinance. And third, the BZA shall hear and decide appeals of the zoning administrator or from any order, requirement, decision, or determination made by any other administrative officer in the administration or enforcement of Title 15.2, Article 7 of the Code of Virginia. In exercising its powers, the board may reverse or affirm wholly or in part, or may modify an order, requirement, decision, or determination appealed. The determination of the administrative officer, zoning administrator, shall be presumed correct by the BZA. The appellant has the burden of proof to rebut the presumption of correctness by a preponderance of the evidence. The board shall consider any applicable ordinance, law, regulation in making its decision and must base our judgment on whether the administrative officer was correct. The concurring vote of a majority of the membership of the board shall be necessary to reverse any order or determination. Now on to tonight's hybrid hearing. For those who are participating in the room, on the front of the table, you will find a QR code linking to a copy of the application package, including the staff report for each case before us this evening. For those participating virtually, a copy of each application package can be found on the Arlington County BZA website. There is also a link in the chat for the application package. I recommend that if you have not yet seen that report for your case, that you review that report before your case is called. If you are attending virtually and lose connectivity, please reconnect with us by phone. If you are attending via Teams, please keep yourself muted and camera off until called upon. Turn off the sound on any other devices around you to minimize interference. When called upon to speak, please turn on your camera and unmute yourself by clicking on the microphone icon that is located in the meeting command bar. County staff does not have the ability to unmute you. The meeting chat is active for technical support assistance only. The meeting chat should not be used for discussion, public comments, questions about agenda items, or requests for more information. All public comments must be shared verbally or have been previously provided in writing for the record during the assigned public testimony period. This evening, staff will call each case and will provide a brief staff report and recommendation. Next, board members will ask any questions of staff that they may have. Applicants or their representative will be given an opportunity to make comments to support the application or appeal. Next, all speakers for the item will be called. Speakers must fill out a speaker's slip either online or is available on the table in the front of the room. After we hear for speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may ask questions of any speakers, but does not permit any cross-examination or direct questioning by others. For tonight's hearing, this board has deemed the following time limits for speakers to be sufficient: 20 minutes for applicants of appeals, 5 minutes for applicants of use permits and variances, 2 minutes for individuals, and 3 minutes for representatives of organizations. After the board has gathered all the information we need and have discussed the case, we will decide the matter by voting on a motion duly made and seconded. A majority of the membership of this board is needed to approve any motion. Please be respectful of the time allotted. This is a public forum, and tonight's meeting will be recorded and posted on the county's website. All information associated with tonight's hearing, whether spoken or written, is subject to the Freedom of Information Act requirements. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you are welcome to stay for the balance of the session or leave at your convenience. Tonight, I have a request from a BZA board member, Mr. Kumana, to participate virtually. Virginia law requires that there is an in-person quorum, and as such, I will note that we have an in-person quorum for the record. Mr. Kumana, can you please certify that you can hear me?
Hi, Richard. Yes, I can hear you.
Thank you. And I will certify for those in the room that I can hear you. And I'll also just note that Mr. Kumana has requested to participate virtually because he is out of the jurisdiction of over 50 miles. With that being said, that's all the business I have to attend to. So let's move on to our agenda. Ms. Ryan, are you calling cases tonight?
Yes.
You call us our first appeal.
Yes. Case number V-12036-24-APP-1, a carryover and appeal by Shannon and Wright LLP on behalf of Alex Wilson of the Community Planning Housing Development Director's Letter declaring EHO permits ZEH 023-00067 void on a permit or property located in the R5 zoning district on the premises known as 1225 North Quincy Street, RPC number 15-083-017, Ballston, Virginia Square. Staff recommends that the board do not object to the applicant's request to defer the subject appeal request to either the February or March 2026 BZA hearing.
Thank you, Ms. Ryan. And we don't have any speakers signed up for this?
This is Zach Chapman on behalf of Wilson Ventures and Alex Wilson. I'm his counsel from Shannon and Wright.
I'm sorry, we'll get to you in a second.
Oh no, I'm just saying I'm just appearing on their behalf.
Yes.
I'm this appeal.
Thank you. Do my colleagues have questions for staff on this, Ms. McCoskey?
So where does this application stand? As I understand it, the appeal is to the letter from Samia Bird that the permit was void. And I guess my question is, could the applicant move forward with this permit as the law stands on the missing middle stands currently?
I'm going to see if Stephen can answer that question.
The short answer is I believe so, but we don't know whether there would be any changes in the future that would cause them to want to still pursue this.
Right. So my concern is if we defer this matter and they're objecting to having to put the notice in the land records, and then they decide they want to move forward. I mean, I think we have another one tonight where somebody moved forward without putting the notice in the land record. So I guess I'm just concerned that we're putting this off for several months. So is a resolution actively being pursued on this? Because as I understand it, that's the reason for the deferral, is that you're trying to resolve this matter between the parties. And my concern would be that if you don't resolve it and the applicant tries to go forward, that's apparently happened. And that's really my concern, that we defer this till February or March, and then we're sort of back in a problem of they've built something that wasn't allowed to be built.
So I think the question may be better given to the applicant in this case, but my understanding is they are pursuing not just this, but they're pursuing other avenues outside of the zoning division through the courts as well. So my understanding is that they are trying to resolve this without needing this case to go forward at all.
Okay.
Mr. Chairman,
Ms. Malice.
I don't think that the BZA has an interest in what happens outside of the BZA. I think our interest is in the facts as presented in the appeal, that they are stating there's an argument, a difference of opinion on whether that letter informing them of the court's decision was a determination. So I think the question that before us is very narrow, and I would be inclined to schedule the appeal on the merits.
To grant the deferral to schedule it?
Oh, well, we can't hear it. We don't have the parties before us
Right.
tonight, but I would move that we schedule this appeal to be heard on the merits.
Question. I assume that the January, February suggestion is because we don't know when we're meeting. I mean, it's unusual to have 2 months in any case like this, but we also have an issue of 2026 scheduling, which is not yet known.
Well, if we technically wanted to schedule this to be heard, we would typically do it 60 days from now, which would be December.
And I think maybe what we ought to do is hear from the applicant, because it sounded like the applicant will tell us why they need that much time. But
And-
because they're pursuing some other resolution that isn't with zoning. So we maybe want to hear that and have the whole picture and then have our discussion.
And my question is that letter not moot now with the reversal?
Could I chime in here? I might be able to shed a little light on what is going on.
Yeah, please go ahead.
So we actually prevailed at the Court of Appeals on this matter, and just this past week, the petitioners, or the other side in this case, the citizens, they have filed a petition with the Virginia Supreme Court. So we're not sure that the Supreme Court is going to take up this matter. We do intend to file a response. We're also actively working with the county to resolve this without the need for a hearing. We've been in touch with the county attorney as recent as today. And the issue that is before the boarding zone of appeals is likely to become moot. I mean, we are actively working with the county attorney to resolve this, and it has been actually scheduled for trial. So this issue might be moot at some point in the near future, depending on what the Supreme Court does, as well as how if we can just resolve this with the county.
What would excuse me, Mr. Chairman,
Mallett.
what resolution with the county attorney's office are you seeking?
So we have currently have a case that we have filed 2 vested rights lawsuits for each of the properties at issue in this case. We're working with Monica Monday with the county attorney's office to resolve this through the court. So there are 2 vested rights lawsuits.
So again, I don't feel like we're part of the vested,
Okay.
what happens in the courts. I think we are part of what is before us.
So
Please.
I'd just like to ask the applicant, so is there any chance this will be all concluded by December? I mean, that would be our normal time to defer something too.
I would be fine deferring it to December with the recognition that I will be prepared to have a hearing on it at that time. If you would just give me 1 second, I can look at my calendar. I believe it has been scheduled for maybe the end of December for technically a trial on the vested rights lawsuits. But again, we're working with Monica Monday from the county attorney to resolve this, and the county is working with us. It's not really a contested issue. There are other cases that are involved that are in a similar position that have already prevailed on summary judgment for this exact issue. So I don't think it's a contested thing really. It's just more getting through the courts at this time. So let me just pull my calendar up and I might be able to tell you when this is set for trial. Trial is set December 15th, actually, on Tuesday or Monday, December 15th, it's set for trial.
Which is 2 days prior to our December hearing on the December 17th.
Then maybe we'll have it resolved by then. If we can set it for, if you're inclined, I would ask that it be deferred to the 17th, recognizing that there is a trial set on the 15th and 16th. That will hopefully resolve any issues, and then we would probably be able to dismiss or withdraw the issue at that time.
So our resolution would be to defer to December for a hearing on the merits.
That would be
And-
fine with me.
And then if there's a resolution, we deal with it.
I'm going to just suggest, and I appreciate your note about what's in the BZAs and what's not. So I'm just kind of thinking that the way these things go, we might want to schedule it for our January meeting, whatever that's going to be, because I think the trial could still be going on and we almost certainly wouldn't have a final resolution unless if the trial actually happens and is what's going to be. So I do think maybe January is the right time to do it.
I would concur with that, because then if that can prevent the advertisement, which is a cost to the county, as well as prep time for the county attorney's office and zoning staff and the parties involved, I would be in favor of January.
That's fine with me.
But from my point of view, we would have a hearing on the merits if
January.
it's not resolved.
If it's not withdrawn,
Right.
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 I think that's right.
Mr. Chairman,
Ms. Malice,
on case V-112036-24-APP-1, I move that we defer this matter to the January BZA hearing, to our January hearing for a hearing on the merits.
a motion for a scheduling of this matter to the January BZA hearing, date to be determined. Made by Ms. Malice, seconded by Ms. Freshman. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice,
Aye.
Ms. Freshman,
Aye.
Ms. McCoskey,
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion to schedule this for a hearing in January on the merits passes 5-0.
Thank you.
Ms. Ryan, can you call the next appeal?
Yes, case number V-12041-25-APP-1, appeal by Shannon Wright LLP on behalf of Alex Wilson of the Community Plan Housing Development Director's Letter declaring EHO permit ZEHO 23-00022 void on properties located in the R6 zoning district on the premises known as 5041 and 5043 25th Street South, RPC numbers 28026-018 and 28026-019 in Claremont. Staff do not object to the appellant's request to defer the subject appeal request to either the February, March 2026 BZA hearing.
Thank you, Ms. Ryan. No speakers are signed up. Do we have any questions for staff? Does the appellant want to address?
Yes, this is the exact same issue that was previously mentioned. These permits are they're the subject of the same lawsuits that were previously mentioned. So the January hearing would be fine with me as well for a hearing on the merits.
Thank you. Ms. Malice.
Mr. Chairman, on case V-112041-25-APP-1, I move that the Board of Zoning Appeals defer this matter to our January meeting for a hearing on the merits.
Second.
A motion for a deferral for a hearing on the merits in January, made by Ms. Malice and seconded by Ms. Freshman. Is there any further discussion? I will call the roll. Ms. Malice,
Aye.
Ms. Freshman,
Aye.
Ms. McCoskey,
Aye.
Mr. Kumana?
Aye.
Chair votes aye. Motion for a hearing on the merits scheduled in January passes 5-0. Ms.
Thank you.
Ryan? I'm sorry?
Thank you.
Oh, yes, you're welcome. Thank you. Ms. Ryan, when we schedule the January agenda, can you put the 2 appeals at the end of the agenda?
Yes, I can do that.
Thank you. And can you call our next, I guess we have a withdrawal, we have 2 withdrawals.
Yes. Case number V-12054-25-VA-1, carryover and withdrawn, a variance request by John Greco, the owner, to permit total lot coverage of 43% instead of 40% as permitted regarding a 1-story addition and new screen porch to an existing 1-family detached dwelling in the R6 zoning district on the premises known as 2607 John Marshall Drive in Leeway Overley. The request has been withdrawn by the applicant and no further action is required by the BZA. The associated case is case number V-12054-25-UP-1, carryover and withdrawn. A use permit request by John Greco, the owner, to permit a rear setback of 1.6 feet to the building wall, 1.1 feet to the building eave instead of 25 feet to the building wall and 21 feet to the building eave as required, to permit right side setback of 3.7 feet to the building wall, 3.2 feet to the building eave instead of 8 feet to the building wall, 5 feet to the building eave as required, and to permit a rear setback of 17 feet to the screen porch, 16.5 feet to the screen porch eaves instead of 21 feet to the screen porch, 19.5 feet to the screen porch eaves regarding a 1-story addition, a new screen porch to an existing 1-family detached dwelling in the R6 zoning district on the premises known as 2607 John Marshall Drive in Leeway Overley. The request has been withdrawn by the applicant. No further action is required by the BZA.
Thank you. And I assume we have no speakers signed up for this, either of those 2 items.
No.
So I think we can move on.
Okay. The next case is V-12059-25-UP-1 is a carryover. A use permit request by Brush Arbor Home Construction LLC, Melody Gates, on behalf of Curtis and Samantha Ophoria, the owners, to permit a right side setback of 5.6 feet to the building wall, 4.6 feet to the building eaves, and 1.9 feet to the window wells instead of 10 feet to the building wall, 6 feet to the building eaves and window wells as required, to permit a right side setback of 5.6 feet to the chimney instead of 8.5 feet to the chimney as required, to permit a left side setback of 9 feet to the building wall, 5 feet to the stoop and areaway instead of 10 feet to the building wall, 6 feet to the stoop and areaway as required, and to permit a total aggregate side yard width of 14.6 feet instead of 18 feet as required regarding a new 1-family detached dwelling in the R6 zoning district on the premises known as 3174 20th Street North in Lyon Village. Staff recommends that the board defer the subject use permit request made at the applicant's request in November 19th BZA hearing. We have supplemental material, which includes emails from the owners, 2 BZA comment forms in opposition, a letter of opposition from adjacent neighbor, and we have 2 additional speakers that have signed up to speak on this.
Thank you, Ms. Ryan. Can you update us on what the status of the plans are for this? Are you in consultation with the applicant on revisions?
Not yet. They're still working on revisions at this time.
So the applicant is asking this board for a deferral. So can I assume that since you have not seen any plans, that November is probably insufficient?
That's correct.
So we're looking at either a December or January deferral, I think. And we can now, I guess I'll call the applicant because it's a normal hearing, so we have to hear from them and then we'll hear from the speakers. But I'm assuming they're not asking for any approvals tonight, so we're on the path for a deferral because that's what they requested. Is the applicant with us tonight?
This is Scott Anderson with Brush Arbor Homes. The applicants, so I'm here, the homeowners are not.
Do you want to speak to the deferral request?
Yes, we have plans modified to minimize the use permit to one side of the house, but we have to share them with staff.
And have you addressed those plans with the significant opposition to your plans?
I'd have to ask Curtis and Samantha, the homeowners.
Okay. We have speakers. Why don't we hear from our speakers? So I'm sorry, my screen's not working. So Mr. Murdad, I probably massacred that. Good evening. Totally massacred that.
Let me get my camera so I can see it.
One of the two that are obviously most impacted by the use permit request. I had other plans prepared, but given that the applicant have the staff.
Oh, sorry.
I had longer remarks prepared, but given that the applicants have requested with the staff's concurrence a deferral, and therefore we have nothing to look at, I'm really going to keep my comments very, very brief. The comments we submitted were on the prior version of the site plan that was posted, and that would result in a very severe impact on the setback nearest to us. So it's very important to us for obvious reasons, but we'll certainly review any revised site plan in good faith. I'd just like to mention for the board's reference that we will likely not be in town for the December meeting. And so we would ask that you bear that in mind, scheduling wise.
I'm sorry, which one will you not be in town for?
The December meeting.
If we do schedule that for December, we do take very seriously any written feedback as well.
Thank you.
Thank you for speaking tonight. And Mr. Kurtz? Mr. Kurtz? We have a speaker slip. Take it, Mr. Kurtz, Adam
Yeah.
Kurtz.
Let's, Adam Kurtz.
That's the camera, right?
Okay. That's
Going once, going twice.
neighbor across the street. The Smith house. Kurtz. Jacob.
Okay. So
Do we feel that, given that the revisions haven't been seen by anybody, that December is sufficient? It doesn't feel like that to me.
yeah, I mean, with the significant neighborhood opposition and some of the nature of the comments that we received,
I
I
would
would
suggest January,
be inclined for January as well.
which would be convenient for the neighbors as well.
Would you like to make said motion?
Sure, give me something to read. Case V-12059-25-UP1, carryover. I recommend, defer the subject use permit request made at the applicant's request to the January BZA hearing date to be determined.
Second.
A motion for deferral to our January to be determined hearing made by Ms. Freshman and seconded by Ms. McCoskey. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice, Ms. Freshman,
Aye.
Ms. McCoskey,
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion for deferral to January passes 5-0. Ms. Ryan, can you call the next item?
Yes, case number V-12065-25-UP-1, carryover, a use permit request carried over from the September BZA hearing by Adam Demento on behalf of Craig and Bridget Stevenson, the owners to permit a street setback of 16.5 feet to the porch, 15.7 feet to the porch eve instead of 21 feet to the porch, 19.5 feet to the porch eve as required regarding a porch addition to an existing one-family detached dwelling on a corner lot in the R6 zoning district on the premises known as 6001 14th Street North in Highland Park, Overly Knolls. Staff recommends that the board adopt the attached proposed resolution granting use permit request with conditions.
Thank you, Ms. Ryan. Do my colleagues have any questions for staff? Ms.
Mr.
Miller.
Chairman, the existing porch encroaches currently. I couldn't tell from I'm not sure I could read from the plans how much additional encroachment the applicant is asking for from what currently exists.
Brett, can you pull up the plat for this one?
I'm not seeing that annotation on the existing plat. Just might take me a second to look at some of the other plans.
I think your mic's off.
Oh, I was just saying I'll take a look through the other plans, but it doesn't seem to be annotated on the existing.
Yeah,
plat.
because I didn't, it just shows
So-
that the existing porch sort of bisects the.
I might be able to help here. I'm actually the applicant. I didn't know if I was able to speak at this moment, but I thought I could help you all
Yeah.
with that question.
Go ahead.
I know it's being referred to as a porch, but it's really stairs. And we are essentially, the plan is to, the stairs turn to the side and they're dilapidated. So the plan is to turn the steps forwards and repair the steps. And then put a cover, a small cover over the top of the steps that currently does not exist. So I don't believe that there's any, it may be, I don't know off the top of my head, but it may be another inch or so forward, or I'm not sure if it's actually the size is actually changing, but the direction of in which the steps face are being altered.
So you're saying that the stoop itself is the same size? It doesn't look like it's the same size.
I'm not 100% sure, but I was just trying to, it might be a little bit larger. I don't have the exact dimensions in front of me,
So I'm looking for
but
the exact dimensions.
I
the
can,
exact dimensions.
in the staff report, Brett has approximately 17.3 feet from that existing stoop.
So the existing is 17.5 from,
17.3 from the street, and then they're asking for 16.5.
okay. And the stairs don't ordinarily count, right?
Not the
The
stairs.
stairs don't count. So,
I guess it depends on how they're designed, but not, these wouldn't need the setback relief.
right. So what's accounting for the additional size of the stoop? That applicant can probably answer that.
What, should we hear from, let's hear from the applicant. Oh.
Sorry, can you repeat the question?
Do you want to speak to your application and then we could ask any questions that aren't answered?
Sure, I wasn't planning on it and was told not to, but I have
well,
a
that's
big
okay.
mouth and I guess I
Speaking
just want to help. I just want this to get passed. That's all.
Speaking is not required. So.
Yeah, no, I mean, again, all we've really thought, all we've really put together here is the idea of turning this, the steps are over the setback, the existing setback as currently drawn, and we want to repair and reconfigure these steps. And I believe, as you've mentioned, expand the footprint slightly to be a little more conducive going in and out of the house. But other than that, I don't have much to add other than that. And then the additional roof coverage for the top of the steps to be repaired.
Thank you. Ms. Malice, did you have any further questions? Discussion with the board? Or a motion? Or are we thinking it over?
Go ahead.
Ms.
and make-
McCosker.
I move that the Board of Zoning Appeals adopt the attached proposed resolution granting the use permit V1206525 UP1, subject to the conditions listed.
Second.
A motion for approval as advertised, made by Ms. McCosker, seconded by Ms. Freshman. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice,
Aye.
Ms. Freshman,
Aye.
Ms. McCosker,
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion for passage 5-0. Good luck with your porch.
Thank you
Ms.
very much.
Ms. Ryan, can you call our next case?
Yes, a use permit, case number V-1270-25-UP-1, a use permit request by Sean and Olivia Abudud the owners to permit a street setback of 19.1 feet to the porch, 18.1 feet to the porch eaves instead of 21 feet to the porch, 19.5 feet to the porch eaves as required, regarding new front porch addition to an existing one-family detached dwelling in the R6 and S3A zoning districts on the premises known as 511 North Manchester Street, Boulevard Manor. Staff recommends that you adopt the proposed resolution denying the use permit request. An alternative resolution with conditions has been provided should the BZA see fit to approve the use permit request as advertised. And note there's supplemental material for the case that came in with neighborhood support from 3 neighbors.
Thank you, Ms. Ryan. Do my colleagues have questions for staff?
I have a comment,
Freshman.
more than a comment. Initially, when I read this application, there was no neighbors input at all. And subsequently, we've gotten, I believe, 3 in the supplemental, only one of which has an address. So I consider that completely useless and a waste of everybody's time. And I understand that people have privacy issues, they send in emails or whatever, but maybe it should be on the applicant to do that rather than having to stand up here and ask, well, who lives at such and such, or where do Jack and Jill live? You know, because all we have are the names. It's just a bug in my head because this has happened any number of times, and it's so important to the BZA that we get neighborhood feedback. And when we finally get it, that it's of value.
Thank you, Ms. Frischman. I will just add that our BZA assistant was not available to assist us this week. And so part of that might explain that, but not all of it. I just wanted to not, normally our assistant would send out emails reminding people to do it a week before, but she was not available this month.
Well, we did have the responses.
Just no address.
They just didn't give us any useful information, which is a non-response.
Right. Anything further? Is the applicant with us? Please.
Good evening, everyone. I'm Sean Abushadid, and I appreciate the board's time this evening on a request that really is meaningful to our family. We're at 511 North Manchester Street. I live with my wife, Olivia, and our 2 sons who are 6 and 2. We are asking, as you saw in the materials, for, I guess it's 1.9 feet of relief from the front setback requirement so that we can build a porch that is a front porch, a depth of 6 feet. And I think it probably should start just by addressing your comment, Ms. Frischman, and I guess offer my apologies. We don't have experience with this process, and we did do our best. I'm happy to provide supplemental information about the neighbor outreach. I'm happy to reach out to more neighbors. When we started the process, we did meet with Mr. Goldberg and Ms. Ryan. They did talk to us a little bit about the neighbor outreach process. We actually asked, what would be necessary and appropriate in terms of the reach out. And it was suggested to us to just really all that was necessary to reach out to the neighbor immediately adjacent to us and across the street. We asked about the neighborhood association. We asked about the school. We're close to Ashlawn Elementary. So that's what we did. So, and I apologize we didn't label it better, but the feedback that you're seeing is from the neighbor who's directly next to us, both the owner and the renter of that property, and then the neighbor who's directly across the street from us. We don't have any other neighbors who are adjacent to us because the rest of our property is adjacent to the park. So again, I apologize. Certainly don't mean to waste anybody's time. We lack experience with the process. Any other questions that I can answer? If not, I have a couple more remarks that I would offer in the time that I have.
Why don't you make your remarks and then we can ask follow up.
Sounds good. So Of course, we reviewed the staff report recommending the denial of our request. As you can imagine, that was disappointing to us. But my, I guess, as you know, an untrained person, I mean, my thought in reading through the report was that there are the 4 criteria for approval of the use permit. You all are very familiar with them. I won't go through them. I think, at least in terms of the staff report, there doesn't seem to be a dispute that 3 out of the 4 are satisfied. It's really that first criteria about compatibility with the development, the surrounding neighborhood, the overall footprint and placement that are similar structures, and so forth. There's no issue with taking down trees, natural landform, or historical features. So I think the staff report helpfully lays out some examples of other properties in the neighborhood that have either porches or other structures that are closer to the street than the rules would normally allow. And the conclusion that's drawn in the staff report is that those suggest that, I guess, that our request is inconsistent with what else is in the neighborhood. I would my view is that the examples that are given actually are supportive of our request, and I say that for a couple of reasons. First, I believe all but one of the examples that are cited are actually closer to the street than we're asking for. So we have a request of it's in here, a 19.1 foot setback. So I believe all but one of them is either equal to or less than that in terms of the proximity to the street line. Many of the examples are not actually porches, but the 2 that are, in terms of the depth, one of them is 6 feet, which is what we're asking for. The other one is, I believe, 7 feet, 7.2 feet, which is greater than we're asking for in terms of the depth. And so in that sense, I think they actually suggest the depth we're asking for is, at least has been approved by the board in the past in some instances. And then third, I think the issue of the square footage with the porch we proposed being a little bit larger in terms of total square feet, or in some cases materially larger than some of these other structures. What I would say to that is, and I know you all have pictures of our home, but our home is a colonial. It's the original home there, built in the mid-60s. And, what we have in mind to build is a porch that goes across the whole width of the front of the home, which is, I think, aesthetically, architecturally, and sort of classically what people would tend to do with front porches in a home like this. I think the other examples, and I know I don't have a lot of time here, but the other examples, one of the porches, that's just a different type of home where it made, I think, aesthetic and architectural sense to build a porch that only took up half the width of the home. I think in those 2 cases, whereas ours, it really doesn't. And that's all that's driving the square feet is the width. So, to me, again, respectfully, as I look at it, sort of what is the issue? What is the concern that would drive, or that did drive the recommendation? I don't, I don't see why it's the depth of the porch, because there have been other porches of a similar depth approved, and the setback that we're asking for is actually less than some of the other, or virtually all the examples that were given. Is it that it is a porch that takes the whole width of the front of the home? I don't think that's the objection.
I think in the staff report, I think that staff's objection was the square footage of the porch is out of character with the neighborhood. I think that was explicitly in the staff report.
Yeah, understood. And so I guess what I'm saying is what is driving the square footage really is the width of the porch, because the depth, I think, is a standard depth. It's the width of the porch that's driving it. And the only reason we have it that wide is because that what makes sense on a house like ours, as opposed to the other examples in the neighborhood where the homes are of a different character. They may be a split level, they may be a rambler, or whatever it is, to where it made sort of aesthetic and architectural sense for the porch to not take up the whole front of the home. So, you know, I think that's you know, if the real concern is proximity to the street, we're actually going to be farther away from the street than these other examples, except for one. The square footage is really only a matter of, you know, the width of it.
Thank you.
My only other comment or request at this point, and by the way, you know, if the board were inclined to adopt the alternative resolution granting our request with conditions, those conditions we're perfectly satisfied with and would be no issue for us. The
Thank
only
you
other
for your
thing,
comments.
am I out of time? Okay, thank you.
Thank you. We're well over. Do my colleagues have questions for the applicant? Ms. McCoskey?
I know this isn't really just want, and I've said this numerous times, because people do want to build these 6-foot porches and, you know, the 6 foot in depth. And I understand that. But it is also correct that throughout the county, the space allowed for front porches is 4 feet by each zoning district. And so I believe there's another basis for denying this request for use permit, which is that it conflicts with the zoning policies of the county. And because this is a standard that applies throughout the county, I don't like to vote for exceptions to it, but I think that's an important note, that the 4 feet is the standard and you're asking to go beyond that. And so just the fact that there's one other somewhere else doesn't necessarily allow that to be approved.
I have just a quick question for staff. I'm looking at the first rendering on the staff report around page 16. And on the right side of this applicant's house, there are stairs, but then there seems to be something going on behind the stairs. Right above that 3 foot marker. Is that part of this?
I can answer that if it'd be helpful, but of course defer to your colleagues first.
Sure. Is that?
Yeah, so the picture is that there's an existing staircase that goes to a side entrance into our home, and that's what's going on behind. The staircase.
That's not part of this porch project.
No,
Okay.
no, that's already.
That was my question.
Yeah.
And Ms. Ryan, the stairs on the right side of the porch, that's not calculated in the square footage of the porch. Is that correct?
No, that's not part of the
Great.
square footage.
Thank you.
And if Brett goes back one slide, you can see the deck that the owner is referring to. On the,
Oh, yeah, I see it on the plat now.
yeah.
Yeah. It looked confusing on the rendering, I guess. Discussion with the board?
Mr. Chairman,
Ms. Malice?
I understand what the applicant is attempting to achieve. You know, a 4-foot porch doesn't have a lot of depth, but that's what the county board has put in the zoning ordinance. And that's what we have to respect, unless there's some compelling reason not to. And I just don't see a compelling reason here to do that. And as staff points out, the fact that the porch extends the entire width of the house just makes it that much worse in terms of encroachment.
Mr. Chairman, I had comments if.
Yes, Mr. Kumana?
Hi, everyone. I'm supportive of this. I'd also, it's probably too late and I should have gone back and read the minutes from the January 2025 meeting. But it seems like in this very neighborhood, so 5th Street North would be right up the road from this house. We approved, and this is a few months before my time, but we approved front porch eaves 19 feet from the road. It's example 1, 2, 3, 4, 5, 19 front porch and porch eaves from the road. That house is essentially a neighbor of this house. So from my perspective, and being intimately familiar with this neighborhood, I do think that it meets the criteria of fitting the style of the neighborhood. And as far as the square footage concern, that the staff may had, it's hard for this house if you look at the map. And again, just being familiar with this neighborhood, this house is naturally wider than the surrounding houses. This is a raised rambler and split level neighborhood, while this house is a colonial. It really does kind of stick out amongst the neighborhood. So if square footage or width is a concern, it's really comparing apples to oranges, whereas the width would probably be more in line with like Leeway Overly a mile north. So just an extra context that this house, although it's 70, 80 years old, it's quite different looking. It's also mostly parkland surrounded, which, considering there are no additional neighbors that, this might encroach on, and it's not a wraparound porch, so it's not encroaching on anyone, also are reasons why I'm supportive of it. Again, just understanding the distance where these houses are from this one. There are porches that are 6 feet wide in this neighborhood close to this home. So I don't agree that it's outside of the scope of, or the style of the neighborhood. So I'm supportive of this, but obviously I'm just one vote.
Thank you, Mr. Kumana. Your feedback, can you tell us which feedback goes to which house?
I'm sorry, what was the question?
The submitted feedback? I don't think we've ever covered that.
Sure.
Which
Yeah.
submitted
It's the one
comment
direct,
forms?
so that's, what is that, 509 is the one directly next door to us. And so there's an owner of that home that provided the feedback that was supportive, as well as a renter. And then the other feedback was the one directly across the street, which is 5901. So those are the two.
There were 3.
The reason so 2 came from the same home. So that 509, we got feedback from the owners who don't live there and from the renters who do live there. So apologize for the confusion there. I also had a question, if this is an appropriate time.
I mean, not really, but what's the question?
I get, my question would be, and I know the board is gonna vote on the request, but if the board was not inclined to grant the request, my question is it possible to get feedback if the square footage is an issue, for example, on what the board might be willing to?
That would be something we would direct you to staff, because staff can pull the comparables for what that compatibility would look like in that neighborhood.
Okay.
That's not something that we have any ability to do.
Fair enough. Thank you.
Ms. Freshman.
I'll just make the comment that I generally agree with Mr. Kumano's comments. When I first saw this house, I was overwhelmed because it is 2 complete stories, and it reads as a very large house for that neighborhood. But when you look at the map in front of us, it doesn't have as large a footprint as the others. And so I think it is a matter of perception. And I guess given its location near parkland, I feel that it is not an unreasonable request. I understand that the real fault here is that the county board has not taken any kind of a position, even despite repeated requests for porches wider than 4 feet. 4 feet is not a porch. 4 feet is maybe a landing. So I think that we need more action. And we've had that situation in other parts of the zoning ordinance where after repeated applications, we've finally gotten some action on that. So anyway, I'm just saying that I think, and generally speaking, despite some of the comments, I'm supportive of the application.
Thank you, Ms. Freshman. While someone contemplates a motion, Ms. Ryan, can you bring up the front picture of the house for me? If someone would like to try a motion.
Mr. Chairman.
Ms. Malice.
I will try a motion. I move that the Board of Zoning Appeals, what's not on the front page? I'll have, just hang on.
Well,
Mr. Chairman,
Ms. Malice.
I move that the Board of Zoning Appeals adopt the attached proposed resolution denying the use permit B-12070-25-UP-1.
Is there a second?
I'll second it.
A motion made by Ms. Malice, seconded by Ms. McCoskey for denial as recommended. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice.
Aye.
Ms. McCoskey.
Aye.
Ms. Freshman. I went out of order. I apologize.
No.
Mr. Kumana.
No.
That's why I went out of order. I'm going to vote no. Would anyone else like to try a motion? Ms. Freshman? Or Mr.
Let me have one.
Brad, next slide.
I need the beginning. No. Okay, never mind. V-12070-25-UP1. I move approval.
Thank you, Ms. Freshman. Is there a second?
Second.
A motion for approval made by Ms. Freshman, seconded by Mr. Kumana. Is there any further discussion? I'm just going to say that for me, this was a tie, and I'm going to give the tie to the runner. I think that this will improve the look of the house, and it's secluded in the corner. It is a little big, but I think that this is probably the best of the options for this particular situation. Ms. Malice.
No.
Ms. Freshman.
Aye.
Ms. McCuskey.
No.
Mr. Kumana.
Aye.
Chair votes aye. Motion passes 3-2. Squeak by.
Thank you very much. You've made my family and I very happy. I appreciate your time tonight.
Ms. Ryan, can you call the next case?
Stephen has his hand up. Is it okay if we ask him?
I'm sorry?
Stephen has his hands up.
Oh, Mr. Rissy, what did we do wrong?
Just for the purposes of the minutes, I wanted to clarify with Ms. Freshman that her motion for adoption was to adopt the alternative resolution with the conditions that staff had proposed.
Yes, sir. I did not have language to read that. Thank
Okay.
you.
Just clarifying. Thank you.
Thank you.
Okay. Case number V-12071-25-UP-1, use permit request by Peter Vanderpool on behalf of Donald and Mary Jurgen, the owners to permit a left side setback of 4.8 feet to the building wall 4.4 feet to the building eve instead of 10 feet to the building wall, 6 feet to the building eve as required, and to permit a total aggregate side yard width of 11.3 feet instead of 18 feet as required regarding an addition on top of an existing non-conforming garage to an existing one-family detached dwelling in the R6 zoning district on the premises known as 6041 22nd Street North in the Leeway Overlay. Staff recommends that the board adopt the attached proposed resolution denying the use permit request. Alternative resolution with condition has been provided should the BZA see fit to approve the use permit request as advertised.
Thank you, Ms. Ryan. Do my colleagues have questions for staff? Ms. Freshman?
I just had a question. In the packet, we have certified receipts for all of the, as I noted, all of the surrounding, including in the rear, but no responses. Is
That's
that
correct.
correct?
We got we only have the mail receipts in the application packet.
Sorry?
Sorry. We do only have those certified mail receipts. We don't have letters from those neighbors.
So we don't have any responses to that outreach. We just have the outreach.
And we will hear from the applicant what additional outreach they conducted.
Okay, thank you.
Any further questions for staff? Hearing none, is the applicant with us? Would you like to speak to your application? And I think there's an arrow. Yep, perfect. And then you can turn it on as well.
I think it's on. I think it's on.
Okay, I don't see the red light, so. And can you also address, I think, all of our concern about not seeing any neighborhood outreach other than the return receipts?
That would be
And identify yourself.
the MK is here as well. So I'm Peter Vanderpool, the architect for the project.
Ah, yes, then you are not the person who will probably address outreach.
Right.
Okay, do you want to address the project first and then we can?
Sure. I had some additional information that I wanted to share with you and also an alternative proposal for the form to share with you as well for your consideration. The lot that we have is the house was built in 1930 and the lot is 50 feet wide, which is less than the standard width for an R6 lot by 10 feet.
He has slides. He provided slides, Brett.
Yep, thank you.
And I guess if you don't mind restarting his time.
Yes.
Okay, sorry.
The zoning ordinance prohibits construction above the garage, a non-conforming garage. There are a number of houses in the neighborhood that have done that, as well as this house. We have one story above the garage to begin with. I don't know when that was built, but we have some other examples. Could we go to the next slide? This is the subject property. You can see the construction above the garage on the left. Next slide. This is a similar house. There are a number of these in the neighborhood. It's fairly common. There have also been similar projects where we have the 2 stories above the garage. If we could go to the next slide. So this is one that was recently built. It's identified as being 7.6 feet, I think, off the property line to the side. And then the next slide, please. And another project is very similar to what we're proposing here, to have the 2-story mass above the garage. And then if we go to the next slide. I know there are other concerns as well. There's topography involved. So this garage is dug into the site. So it's the prominence of the house is a little bit less than in other houses in the neighborhood. And also if the concern is about building, having that 2-story height, the neighbor has already is up in that area as well. So there's a precedent for that and it won't be, I think, insulting the next door neighbor. Could we take a look at the next slide? So I had shown the previous one to show how the garage was dug in and how it minimizes both the house and the addition on the top of it. This is a couple blocks away from the subject property with the garage at grade with the 1.5 stories above it. So what we'd like to show also is, if we could look at the next slide, this is what we had proposed as a part of this submittal to the BZA. We had worked through with the client on several different options for the front elevation. If we could take a look at the next slide. So what we were proposing as an alternative would be to continue the existing front gable roof all the way across and then place a similar dormer on top of that if the concern had to do with that gable facing out towards the street front. And that's all I have. Thank you.
Sorry, so that last slide, that's, you're offering that as an alternative?
Yes.
Okay, well, we could address that if the time comes. The applicant,
Is MK Yurgen?
yes.
Hi, good evening. Thank you all for your time. Just very briefly, my husband and I have lived in this home for the last 15 years. We have two boys who were, well, one wasn't born when we moved in. To answer your question about the outreach, we felt that the most respectful way to communicate our intention was via a certified letter so that people would know that this was something that was coming their way. We have very good relationships with all of our neighbors. There's lots of change and adaptation that has happened since we've lived there with, a full reconstruction across the street. It's not a conversation that we've ever had with anyone else in the neighborhood who's made these kinds of changes. So it wasn't something that we felt compelled to do, but are happy to if that's something that makes the board feel more comfortable. We're very well established in the neighborhood. This is a change that we hope we can make to continue being able to have the house accommodate our family's needs.
Thank you. Do my colleagues have questions for the applicant or the architect? Discussion with the board?
I do have,
Malice.
I guess I have one question. If you are proposing a modification, when would you have plans?
The floor plans would not change substantially with this. It'd be the same. They had hoped to put a bedroom for their son above that garage. That's still the same proposal. We're required to have an egress window. That would be on the side of the house. So there wouldn't be any substantial changes to what we've worked through with the scheme.
But you would need new architectural drawings.
Yes, we'd have new elevations.
Thank you.
Anyone want to make a comment?
Mr. Chair,
Miss Malice.
who's that? Is that the owner in the picture?
One of the homeowners.
Miss, who is on our screen?
The
It's my
second owner.
husband.
Oh,
Sorry.
I was looking to see if you had a speaker. Sorry.
I'm
Hi,
here if you need anything. This is Donald Grayson.
thank you, Miss Malice.
In case.
I don't know what my colleague's pleasure is on this item. I would feel more comfortable if we had more comprehensive outreach done to the neighbors, because it is a major change to the facade of this house, asking for some significant relief. But I also don't know where my colleagues are on the actual proposal, if that is helpful or not.
Mr. Chairman.
Ms. Freshman.
I appreciate the certified letters, but it generally is better for us and is noted on the application about a neighborhood outreach as well, that there's actual conversation. So the plans are shared, and most often we end up with a petition that people sign or individual responses. So that's why I had asked if there had been any response to the certified letters, because sometimes people do send that, especially if the actual owner is absent or overseas or something like that, where it's not practical to do that. So, but I'm very sympathetic to the application in general, especially because the lot is substantially below in width from what is generally allowed. I would like to see that your neighbors agree, although I understand, having gone by there, that there's all manner of renovations and replacements, which is not unique to this neighborhood. We see it in every neighborhood as people try to stay where they are and expand their property. So I'd be in favor of perhaps a 1-month deferral so that you could actually follow up on your certified mail with some feedback directly to us, as well as if you decide that you want to go with your alternative, that would require modification of your plans as well. And that might I don't know how that would work with the advertising requirements and the time that the staff would need to put into it, but they can respond to that.
Mr. Chairman?
Ms. Malice?
With respect to an alternate, to the extent that I guess we would want to know if that changes staff's recommendation. So there might be, I think from your standpoint, there might be a conversation with staff about the alternative proposal and whether that addresses any of their concerns. But I don't think they can address that without plans or something in front of them. So maybe there's a deferral, there's a conversation, and certainly if staff is more amenable to the alternative, then there's a period of time that you'll need to provide drawings for them.
And when the outreach is conducted, you might find conversations with the neighbors to lean more one way or the other. That might be helpful as well.
A question in terms of timing, if there are going to be changes to the plans, what does that do to November versus December? That's a
I
staff
think
question.
that's the determination.
Right.
Although, Ms. Ryan, if I know you don't have plans in front of you, but it looks like it's a pretty minor change. Does that affect, if there are any changes, would that push this to December?
I think if you could get plans in by Monday morning, we could review in time to advertise for the.
But I think there needs to be a conversation too.
Right. So,
yeah.
So December.
At the earliest.
how do you feel about December?
Could you repeat what you said, Meg?
I was saying if we got revised plans by Monday morning of this upcoming Monday, that we could advertise in time for the November.
Yeah, we have them in the can. We can provide, so it would just be the elevations. The floor plan won't change, but the side elevation and the front elevation.
But if having meaningful conversations with your surrounding 7 neighbors would be the result of that. So is that enough time is the question.
I just need to say that the neighbor who's most immediately impacted by this change is unwell physically. And so, I want to be very thoughtful about how we approach her. She was the main consideration for why we sent a certified letter. She's battling multiple things. So we, of course, will be considerate, but, I want to just flag that as a courtesy that we were trying to be thoughtful about.
Well, we can respect that and address that as part of the aggregate of of comments.
But that's just one neighbor. So
absolutely.
So see, in terms of the sequence, you need to produce new plans, see if that changes staff's view on acceptability of it, and then also have time to take those plans around and show your neighbors. I'm having trouble seeing how you can do that in a month.
So, yeah, so I think what we have here is a situation where if the applicant wanted to move forward with the plans that were already submitted and what we already have, then certainly we can look at December and ask that you do as much follow-up as you can to get something for us from neighbors saying, yes, I am in support of this. And generally people don't seem to have a huge problem getting that. But if we were going to look at the alternative proposal, we'd only be looking at one proposal next time, and we might not do that in December. So I don't hear lots of concern among the BZA members about the application that's before us. And I appreciate that you attempted to kind of narrow it down by using the dormer instead of the big front piece, but I haven't heard a lot of BZA members say they have a big concern about that piece. Whether you make it down to a little dormer or keep it as it is, I don't think that's been identified as a big problem. So it really was be kind of up to you, but I think if we deferred it to December, we'd be considering what we have before us now, because there probably wouldn't be time to squeeze everything in for a revised proposal.
Yes, we're not a design board. We don't design things, and we wouldn't consider A or B. Choose one. It has to be whatever you want to submit, and what's already been submitted. I think Sikorsky is right that you're not hearing a lot of negative comments about what is before us now. Though I appreciate the alternative as well. So I think, yes, the answer is that if this is what you're going to come forward with, then the primary consideration is the neighborhood feedback. But it also would be valuable to talk to the staff about their concerns, since they're not supportive, to see if that can be turned around. We could still approve it despite that, but it's always better if you have staff support. So that allows you time for that kind of staff outreach as well as neighborhood outreach.
So my only thought was that we've already deferred a bunch of, I guess we deferred a bunch of stuff to January, not December. So I withdraw that.
Motion?
Ms. Freshman.
On the case V-12071-25-UP1, I move that the Board of Zoning Appeals defer this case to the December 2025 BZA hearing for the reasons that have been discussed.
Second.
A motion for deferral until December made by Ms. Freshman, seconded by Ms. Malice. Is there any further discussion? I just wanted to commend the applicants' comparables pictures in their presentation because I was leaning the other way coming into the room. But I feel that they had established other 3-story, although those might not be going into the setback, it established that compatibility with the neighborhood. Anything further from my colleagues? I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Ms. McCoskey.
Aye.
Mr. Kumana.
Aye.
And chair votes aye. We'll see you in December.
Thank you very much.
Thank you.
Ms. Ryan, can you call the next item, please?
Yes, case number V-12072-25-UP-1, use permit request by Stephen Tinter, Cook Bros Design, building remodeling on behalf of Harris Rubin and Emily Atkinson, the owners, to permit a street setback of 21.5 feet to the building wall, 20.8 feet to the building eve, instead of 25 feet to the building wall, 21 feet to the building eve as required along North Masson Street, and to permit a street setback of 24.1 feet to the building wall, instead of 25 feet to the building wall as required along 23rd Street North regarding a 2-story addition to an existing 1-family detached dwelling on a corner lot in R6 zoning district on the premises known as 5901 23rd Street North, Leeway Overley. Staff recommends that the board adopt the attached proposed resolution, partly granting and partly denying the use permit request, with conditions granting the requested street setback reductions from North Masson Street and denying the requested street setback reductions from 23rd Street North. An alternative resolution with conditions has been provided should the BZA see fit to approve the use permit request as advertised.
Thank you, Ms. Ryan. My feeling here is that this is either an approval or a denial, that there's not really a partial option based on the plans. Right, because if we want to do a partial approval, we would want to see new plans because that's a significant change to the entire proposal.
We had some in the past that we partially granted and denied.
Okay. Ms. Malice?
Yeah. If the pieces were not contiguous, this is one addition that if we don't approve one side of it, it really changes the entire configuration of the drawings. From my standpoint, it would seem they would.
Yeah, I agree. I think that's just up to us, though. I think, you know, from staff's perspective, if we approve something partially, then, you know, I think that
but-
those requirements are up to us.
It's just that
Right.
our approval typically refers to a set of drawings that wouldn't exist if, you know, if a certain setback is not allowed.
Is the applicant with us? Is that on?
Oh, there you go.
Yeah,
Okay.
thank you.
Stephen Tinter with Cook Brothers Design Build Remodeling. I've got the homeowners here as well. To your point, just before the homeowner had something to add, and I was going to talk as well, but I have a drawing that I brought in. I wouldn't have a chance to get it to you guys beforehand, but that shows the extent of the encroachment on that 23rd Street side. And I can hand that out to if you are willing to take a look at it to see just the extent of it. It's really not a whole lot. The homeowners are amenable to pulling that front back. I think we're dealing with about 11 inches. And what we basically would do is just pull the front face of that back by that 11 inches because it's the front triangle basically that, like I said, I've got these drawings. If you'd like to take a look at them, that shows the extent of the encroachment. So is that something we can hand out? Oh, I think I've got it up there. Let me.
Thank you.
Thank you.
And then I've also just got the a drawing here of what it would be to pull that back 11 inches. So I think you'll be able to see that it's not a very significant, it wouldn't impact the overall exterior, you know, of the project at all. So I'm gonna let the homeowner address your other comments, then I'm happy to answer any questions about the design as well.
All right, well, thank you for your time. And, you know, I had written a little bit about myself and why we're making this request. You know, my name is Harris Rubin. This is my wife, Emily. And, you know, I am a native to this area. I went to, you know, Tuckahoe Elementary, Swanson Middle School, Yorktown High School, was also an Eagle Scout, completed my project at the Potomac Overlook Park. And one of my dreams has always been to, you know, own a home in Arlington, something my mom wasn't able to do growing up here. And after graduating University of Virginia, I came back to this area, met my wife, Emily, in 2015, and we bought a small 2-bedroom home on 23rd Street. Over the last 10 years, we've saved up to make some improvements. Our main goal is to expand on a small galley kitchen, at a main floor bathroom to accommodate some of our elderly family members who have difficulty navigating the staircases to the other bathrooms when they're visiting. And, you know, the primary reason for the additional 11 or so inches would just to accommodate a bigger, you know, toilet area, large enough to accommodate, you know, family members with mobility issues. And as far as the second floor, having a laundry room, as we plan to make this our forever home and age in place, it would reduce the number of stairs going up and down. So, you know, we certainly, it's, you know, up to you. We're happy to accept whatever decision you make, but certainly look forward to hearing your feedback.
Yeah, and I use the rest of the time just to point out that I think the zoning office, they said they couldn't find anything that was kind of proud of the front face of the existing house that encroached on that front setback. I've actually got a couple photos also of neighbors' houses. The neighbor actually directly to the left of the property has the exact same type of an addition. And there's a photograph of it on the on the handout I've gotten there, and because of the way the property line actually is at an angle, that structure is actually appears closer to the street than our property is. And there's also another example, like 4 houses down, that there is a 2-story structure that's front facing, is about 18 feet from the house. So I don't think that we're asking for.
But those are not encroaching though, correct?
Well, the one that's 4 houses down, I think it's 2004. You'll see it. It's the picture at the top. That I don't know the exact amount, but I stood at the curb and measured with a laser tape to the front of the house.
Not a corner lot. Different.
Not a corner.
Different
lot,
issue.
Yeah.
Right. It's hard to compare that one because it's a different issue.
Well, I think what I was getting at is that it actually is the front facing facade of the house. And the way I read the staff report, they had an issue with technically the front of the house and how we were coming forward of the existing facade of the house. And so that's why I was just saying that there are.
Well, that one is not, I mean, it looks like the front porch is encroaching, but the rest of the house is all at the same.
But it's about 18 feet from the curb. So it's not, I don't believe that the house is conforming to the 25-foot where we're just about 11, like we're much farther back than that example. That was my point there. There are a lot of houses, if you look at the GIS mapping around that area, that are much closer than what, we're just asking that 11. And like I said, I provided that drawing just to kind of show the scale of what we're asking for. And it does make a big difference from a design perspective. One of the things we were trying to achieve with that bathroom in the space for the toilet is to have an area with the toilet braces that you put it so somebody can help get up. And the extra 11 inches really makes a big difference for someone to be able to help somebody to get off of the toilet. So they're amenable to pulling that back, that 11 inches, and shrinking that down. It just makes it a little bit less convenient for what they're trying to accomplish with that.
Do my colleagues have questions for the applicant? Ms. McCuskey.
Yeah, because it's a corner lot, you have more ability to encroach into sort of the rear yards, the other 2 sides, the non-street sides. So why is there a good reason why this addition is being placed here on the side and encroaching into street setbacks instead of going back and taking area where the screen porch is now, so that it would be allowed by right at that point, wouldn't it?
Well, yeah, I mean, so there's obviously the cost of removing the screened-in porch. That's a feature that's there. But it was also for what we were trying to accomplish. Like on the back of the house, you've got more set fixtures there. So you've got the stairs that are taking up a good chunk of the back side of the house. And we're also trying to preserve the kitchen. So this is not like your typical like enormous 2-story addition kitchen family room. They're just trying to get a little bit more pantry space. And so that's why we figured just moving off to the side would be a little bit easier. It also up on the second floor for the access, it's a 2-bedroom house. So we're not trying to add like a 3rd bedroom or the primary, like to go out 16 or 18 feet towards the rear. They really were just trying to get a little bit the laundry upstairs and like a closet. So that's why we thought that it was, utilizing that side of the yard. We didn't feel that it was that out of character with the rest of the neighborhood and the other houses on that corner. So.
Mr. Chairman?
I'm sorry, Ms. Mellis.
Yeah, so the plans that the plat you laid out, I'm looking at that, and it's like, I guess you have a garage, you have a deck, you have a screen porch, and you have 2 patios. Is that accurate?
On the existing property, yeah, there's a garage that's actually not a detached garage.
It's an accessory structure.
3 porches.
And you have porches, patio.
Yeah.
So I'm looking at, a lot of stuff on one lot. And I have a similar question. You have options to build elsewhere on this lot. And I guess your argument is that you want to preserve all these other elements as well as doing the addition.
Well, and there's a lot on the property, but it's not all, like, if you look at it towards like the lot coverage and things like that, it's much less than a lot of properties in the area because the structures that are there, the deck is lower. There's a screened-in porch and a deck on that back side there, and then there's the old garage structure that's there, so.
I think it would actually, I believe we talked about going towards the back and it would double the cost of the addition to manipulate in the back. We'd have to redo the foundation and everything.
There's a basement walk out there. Like I said, there's a lot along the back side of that house.
Yeah, there's
and-
a lot going on here.
Yeah, and what we figured is that it's a fairly modest, like I said, we're not trying to get the big kitchen family room or a primary bedroom suite. It's really just to get a little bit more elbow room in the kitchen for them. We didn't want to have to tear out the whole entire kitchen, whereas if we went rearward, the whole kitchen most likely would have to be torn out to make it work. And that's why we just didn't feel that the side was a very, and we actually had spoken to zoning beforehand. Before we pushed forward that extra 11 inches, we talked to them about the side, and the feedback that the homeowners had gotten was like they didn't think, I think they spoke with Ms. Cordova in the zoning office as one of the reviewers. And she was like, yeah, like you're only asking for a couple of feet on that side. She didn't think it was a very onerous application. She thought it would be fine. So that's kind of why we went down that route. And then, like I said, the bathroom on the first floor came a little bit after that as we were looking at the functionality of it and what we can fit where. And then that's how we came forward with that 11 inches.
And we have talked to all the surrounding neighbors and they're all on board for, the addition.
Mr. Chairman,
Ms. Freshman.
I can appreciate all the wishes and desires and not to tear up the rest of the property. I might be more sympathetic if this, for it to project beyond the front of the house if it wasn't a corner lot. But the minute I drove over there and looked at it, I said, 2 stories projecting beyond, no. I feel as if that there's a large pantry, there's a lot of space to work with. And I feel that I understand that the neighbors next door have a similar thing, but they're not on the corner. And it does make a difference.
Thank you, Ms. Freshman.
Yeah. There's 2 setbacks being requested, the front and the side, and I guess staff has found that the side setback would be somewhat compatible. But I'm not even sure I'm there on that. Certainly what Ms. Freshman says about pushing this all back would be a first step.
May I
Would-
add something up to that or no?
Would there be a scenario in which you would push this back and line it up with the front of the house?
I don't see where we'd be able to get a first floor bathroom in it if we did that. I think that would be the biggest problem. I mean, the way that I read the staff report when it came out was, I felt like they seemed like they were in support of the side, there's 2 frontages, but the side elevation encroachment. And that's why we had looked at, well, can we pull that front encroachment back to be done by right and push everything back by the 11 inches, which still would get us the bathroom there. And that would make the front be able to be built by right. Then it would only be the side that's there. And I understand the point on a corner lot that the farther forward you come, that side encroachment becomes a little bit more onerous, but
But when a project's not built by right, we look at the compatibility of what the whole project being designed, not just, I mean, in the project that's before us, everything's encroaching. But even if you push it back the inches, we would still look at that as for compatibility,
okay.
right? That won't negate any compatibility analysis that this board will do.
Well,
I'm just,
yeah.
I sense that we're going for a denial, and so I was kind of fishing to see if a deferral for a retry, with a different plan is worthwhile.
Well, I mean, we certainly are amenable to looking at it rather than shutting the whole project down. We really didn't, we figured reading the alternate resolution that they found compatibility with the side encroachment. They just were, recommending denial because of the front encroachment.
I think our views are sometimes independent of staff's
Absolutely,
recommendation.
sure. Yeah. I'm just explaining kind of how we prepared for
Right.
tonight and why we figured that was okay. And there are actually, if you look in that neighborhood, the homeowners, when I saw the other property that I pointed out there, they had pointed me to the corner lot that was closest to Langston Boulevard. And they said, yeah, it just seems if you, I didn't get a photograph of it because there's a lot of bushes and stuff, but it almost seems like on that, the side lot on that is probably within like 4 or 5 feet within Langston Boulevard. I'd never noticed it. My office is right around the corner, but there's just a lot of bushes and real tall. You can't really see the house, how close it is. But so I think that there are, like I said, when I looked at that, I was like, yeah, there is compatibility for like the side lot being very close to a right of way in that neighborhood. And again, I just didn't know if those were built original or if they were done with use permits so they didn't get flagged on the staff report.
Once again, we have a dilemma. I'm inclined not to support this for the reasons that I already stated. If they want to take another stab at it based on the comments, then I'd say January.
I will just one piece of input, and I don't like the sticking out into the front yard, but I do see, looking at the plans, how this is definitely the logical place for this addition to go on the house, because the pantry goes right off the kitchen. And, even if you tried to put it in the back by where the screened porch is, it doesn't fit as well. You could make it fit, I suppose, but it would be much more difficult. This is a dilemma.
I mean, just kind of looking at it, I mean, if the pantry can get a little smaller and you can put the bathroom still in that corner, everything just gets a little smaller. Right, there are other options, is my point.
Yeah, it's difficult when we start designing the inside,
No,
and
that's not my intent.
yeah, no, I mean,
There are options here.
and we look to the professionals to figure out how to make things work. We're really looking at the outside here. And I'm with Ms. Freshman here. I don't see this as an approval under the present conditions.
I'm prepared to make a motion to defer to January if there's any support for that. as an alternative to denial.
I would be interested to hear if that's what the applicant prefers.
My wife might have one final comment, sorry.
I think it's just limited to whether we're interested in a deferral. I don't think we're going to be changing our minds.
Defer to December.
Well, I would just say, and I could be wrong, but I believe that the concern about that is that if you make changes, which would probably be needed, we can't get the input and go through the advertising process in time for the December meeting, because it takes, you'd have to get the changes into staff very quickly, but then they couldn't, I don't think they could do it by December. Normally, we don't do, the only deferrals we've done for 1 month are those for just getting more input on advertising with the plans that have already been done. When there has to be a change in the plans, we almost always do 2 months.
I think we have the alternative available. We could do that very quickly. I mean, we did bring one alternative tonight.
December would allow 2 months because we have the November hearing in between now and December.
Oh, what month is it? This is what happens when you're retired. I'm sorry. Thank you, Meg. So we could do December.
That's correct. Yeah, we could do December.
Okay. Sorry.
We're loading it up already. We don't even have applications for December.
We also have those 2 appeals for January too. So
But we could do this and I'm sorry.
I'd be more in favor of December if
I'm fine with
if I were
December.
to be asked.
Yeah.
My opinion often doesn't matter though.
Mr. Chairman, I
Miss-
make a motion.
Ms. Mellish,
In case V-12072-25-UP-1, I move that the Board of Zoning Appeals defer this matter to our December 17th hearing.
thank you, Ms. Mellish.
Second,
A motion made by Ms. Freshman for deferral until December 17th.
Made by Ms. Malice.
I said that.
Oh, I thought you
No.
said.
No, did I say?
seconded by Ms.
Yeah. Oh, okay. A motion made by
It's not
Ms.
that late.
I swear I said.
That usually happens at midnight.
This one, I think I got, I'll watch the tape. A motion for deferral till December 17th by Ms. Malice, seconded by Ms. Freshman, for deferral till December 17th. Is there any further discussion? Hearing none, I will call the roll. Ms. Freshman, Ms. Malice.
Aye.
See, now you've gotten me. Ms. Freshman,
Aye.
Ms. McCoskey,
Aye.
Mr. Kumana,
Aye.
chair votes aye. Deferral passes 5-0. We'll see you in December.
Thank you.
Thank you.
Ms. Ryan, can you call the next case?
Yes, case number V-12073-25-UP-1, a use permit request by Heidi Fitzharris. Fitzharris Designs on behalf of Sandra and Mark Bushing, the owners to permit a left side setback of 4 feet to the building wall, 3.6 feet to the building eave, instead of 8 feet to the building wall, 5 feet to the building eave as required, and to permit a total aggregate side yard width of 16.4 feet instead of 18 feet as required, regarding relief for the reframing of an existing 1-story office on the left side of the dwelling to an existing 1-family detached dwelling in the R6 zoning district on the premises known as 4808 11th Street North in Waycraft Woodlawn. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you, Ms. Ryan. Do my colleagues have questions for staff?
Just to clarify, the whole structure is completely boarded up. So I guess that everything else is being done is by right.
Yes, I believe zoning and the applicant can.
So it's just the vaulting of the
Yes.
ceiling of the existing
And
Yes.
reframing the wall. They
side
have,
addition.
Yes, and so
Yes.
reframing
Okay.
that wall.
they have a current building permit, and I talked to the zoning plan reviewer. They didn't initially think they were going to reframe it, but then after starting the work, they realized they wanted
It
to do
reads
that.
pretty overwhelming from the street. Thanks.
Can we see the pictures again? I looked at the wrong person. Where, did someone go out and take real pictures?
Yeah, Brett, can you?
That's what I'm saying.
Okay.
Yeah. I didn't make it to this one.
Oh,
So we are still working on that roof line. Okay. Any more questions for staff? Is the applicant with us? I think it's not on.
Okay, I'm Heidi Fitzharris. I'm the architect and the owners are Mark and Sandra right here too. Yeah, so the majority of the project is all done by right. This was an existing structure. And as noted, it's an 88-year-old structure that was existing. And we aren't changing the footprint. It is 4 feet off of the side property line and that's remaining. And we need to rebuild the wall because the new ridge beam that would go across will land on that existing foundation line. And it also needs to be fire rated, which it is not currently. So there's multiple reasons why it behooves the project to renovate this existing structure.
Can I just ask, because we have so many times when people come back in, and my understanding is this is, the same as we're approving, the same as is existing. Can we try to really ensure that there isn't a mistake made and you have to come back later for more? I mean, we frequently see this when they build it, suddenly there's a problem and they're further into the setback and they have to come back after the fact to get it, but.
Yeah, so this is an existing foundation, the existing brick that's not changed. It's all existing. It's an existing wall. We do need to actually, because we are touching it just to put in a post for that new ridge beam, because we're touching it, then we need to make it fire rated because it's less than 5 feet off the property line.
Okay.
So if there was any error, it would be by the surveyor, and that's
okay.
It's all existing.
Okay.
Well, the surveyor errs on you too, unfortunately. It would, yeah, if there was a survey error, if there's any question about the survey, that should be double checked because you would still have to come back even if it's a survey error.
Correct. And there was an existing old survey and a new survey, and they all say it's all 4 feet off the property line.
And any cladding or any, that would extend into the setback would also count.
Yeah. No, it's all, there's an existing brick water table that wraps around, and then the new 2x4, 2x6 wall will be inboard of that. So everything will be
Everything's accounted for.
built according to what it is. Yeah.
So
okay.
you're just getting all of our
You're
upset over other cases. So
no, we've been here
Sorry.
all night and we've heard just how many people are, have been here multiple times.
We've also had cases where people literally had to come in for inches because of siding or some other kind of thing. And where we've had applications where they actually build in a little wiggle room to avoid that. So just take care that when they do a wall check and,
In other projects where I've
happens.
submitted in the past where it's a new wall, then I will also do that. I add in 2 inches of tolerance. But no, this is an existing foundation, existing structure that we're just trying to renovate.
okay.
motion.
Go ahead.
Can you? I move that the Board of Zoning Appeals adopt the attached proposed resolution granting the use permit number V1207325 UP1, subject to the listed conditions.
Second.
The motion by Ms. McCoskey, seconded by Ms. Freshman for approval as advertised. Is there any further discussion? I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Ms. McCoskey.
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion passes 5-0.
Thank you very much for your time.
Thank you.
Thanks for waiting. And I believe we have one more case on our agenda.
Yes, case number V-1207425 UP-2, a use permit request by Roger Bohr on behalf of Daniel and Rosa Narjasul, the owners, to permit street setback of 10.6 feet to the building wall, 7.4 feet to the building eaves, and 9.7 feet to the deck, instead of 25 feet to the building wall, 21 feet to the building eaves and deck as required, and instead of 21 feet to the deck as required, all from South Edgewood Street regarding a two-story side addition with an attached one-story deck to an existing one-family detached dwelling on a corner lot in the R6 zoning district on the premises known as 2800 20th Street South in Green Valley. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you. Do we have questions for staff?
This is the same application that was approved. It just didn't pull a permit time.
That, and then there are some slight modifications to the setbacks they're requesting.
They've increased the request.
Okay.
Is the applicant with us?
I'm here and the owners are here also. I'm Roger Bohr and the owners, Danny Ewell and Rosa, are here also.
And you are?
Daniel Ewell.
Who would like to speak first?
Danny, would you like to speak? Or would you like me to?
You go ahead.
Okay, yeah, so this application was approved before. The addition that was originally approved was just a second story addition up on piers. As they started working through the building plan process and everything, they realized that essentially we're just wasting all that space and it would not be much more, monetarily wise to make that a true two-story addition instead of an addition on piers. And so they redesigned it, and made this request for that. And that's why we see the difference there. And the difference in it is just minor differences for the structural design and the siding of the walls and stuff like that. That's how it's closer. And then the eaves on the addition were revised to be 3 feet instead of 2 feet so that they match the front eave on the house, of the existing house.
Yes, sir.
Next.
No, there's nothing to add. He's pretty much said it all. And like I said, this has already been, we came up here before, and then when it went through the permits, and as they was looking at it, they also mentioned that, I asked for 14 feet, and then they said the eaves was a little over. So, and then if I was going to put stone on the side, it was just, I just needed more space. And this is nothing like Mr. Rogers said, there's nothing totally different than what we initially asked for. But I still did all the outreach that was needed.
Any questions for the applicant?
I have a question. You have an approval for an exemption to the resource protection area?
Yes, we already went through all that. Go ahead, Roger.
Okay.
Yeah, we already have that approved.
Okay. So I guess one thing that, well, I'm not going to ask my question until I look at a little bit more on here. Sorry.
It's okay.
So do the dimensions of the setbacks change?
Yes, on the setback, it went from 11 feet to 10.6 for the actual building itself. And then the eaves went from 9.9 to 7.4.
So essentially, you're just filling in the open space?
Exactly.
Underneath?
Exactly. That's right.
Yes.
Originally, the addition was just on the second floor and it was for piers. And then we're filling in the pier area that was just open airy space previously.
But our eaves are getting a little bigger and our setback relief is getting a little bigger.
Right, exactly. Yeah.
And that is because
in the redesign, accounting for the siding and the structural design, we needed to make the addition just slightly bigger so that we accounted for all of the materials and everything. That is for the 0.4 feet, that additional that we're asking for. And then the eaves are 3 feet instead of 2 feet previously. And that is because we're matching, architectural wise, we're matching the 3-foot eave along the front of the house. Of the
Some of the
existing
front of
house,
the
yes.
house.
Yeah.
Not all of it.
Some of, yes, it's the existing house has a mixture of 3-foot and 2-foot eaves. And that was an architectural decision, by the architect and the owners.
Ms. McCuskey.
Yeah, so I guess my my thinking about the resource protection area was that you're building on this side when again you could probably go back, except maybe you can't because of the resource protection area, and it looks like maybe a slope problem.
Yes, and then that goes back, further back, is almost like a 50-foot drop. So even taking the back, it just didn't make sense when I got so much asphalt, areas that's, I don't have to worry about, destroying any trees or anything. And then with the runoff, of the property being sloped, it was just best to go outside because to the left side of that.
Okay.
Right. Yeah. I was just going to interject here. If you look at the addition that we're proposing compared to the existing conditions now, the whole addition is on top of existing impervious area. So we don't have we don't have a major impact going on for the RPA in terms of extra impervious area and such in the RPA. And that's why our approval went through.
Okay. All right. But there's also a reason why you can't go back into that area further, which is
Right. Yeah.
slope plus RPA. Okay.
Right. Exactly.
Thank you.
Yeah. It starts to go down there.
Okay.
Get a motion up.
Give me a motion.
I move that the Board of Zoning Appeals approve the attached proposed resolution granting the use permit V120425 UP2, subject to the conditions listed.
12074.
Thank you.
Second.
A motion by Ms. McCoskey for approval as advertised, seconded by Ms. Freshman. Is there any further discussion? I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Ms. McCoskey.
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion passes 5-0.
All right, thank you very much.
Thanks for waiting through that meeting.
That's okay. Thank you.
Cheers.
Take care.
We have minutes to do, but I can't remember if I emailed everyone or, okay, so, and I believe you were virtual, so I think you can address that change, right?
Yes. The minutes need to reflect that I was located in Avon, North Carolina. And that is why I appeared virtually. It was for personal reasons, and I was located in Avon, North Carolina.
I move approval of the minutes from September 17, 2025, with the changes just stated.
Second.
A motion for approval of minutes as amended, made by Ms. Freshman, seconded by Ms. Malice. Any further discussion? I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Ms. McCoskey.
Aye.
Mr. Kumana.
Aye.
Mr. Rissy has a hand up, but so motion for the minutes passes 5-0. Mr. Rissy.
Yep, just looking for clarification. Do we need to state the location that you were in or just that you were outside of the jurisdiction?
I believe we should I believe we're supposed to state the location.
Okay.
But I will confirm all that with an email in the next 24 hours to everybody.
Wonderful.
Okay.
And if
Thank you.
needed, we could make a change.
Yep.
Yep.
All right.
Any
you.
other issues for us to address? Staff, nothing? The agenda hereby having been complete, this meeting shall be adjourned.